you can put it in your main privacy notice, or you can have it as a standalone. The key thing to take away from it is you need to tell your employees what you're doing with their data. So there needs to be something, whether that's a standalone dedicated notice or whether it's part of your main one is up to you. One thing I would say is that if you're putting it as part of your main one, just be mindful that you are trying to tell people as quickly and succinctly as possible what you're doing with their data. So if it means that your kind of main privacy notice is going to get really long and really difficult to read, that's the kind of area when you start thinking about, do I want to separate these out into other things? So the answer is maybe. My recommendation is yes. But the fundamental is if you're processing personal data of individuals, you need to tell them what you're doing with it under GDPR. There's a principle of transparency. And so when it comes to the privacy notice for employees, there needs to be something in place, is the quick answer. Kind of format you do it is, like I say, flexible, but you definitely need something. And recommendation is yes, so that is a dedicated standalone document. But you don't need to agree to an employee privacy notice because it's a privacy notice. It's telling you what you're doing with personal data. No one has to agree to a privacy notice, whether that's customers or employees or anything like that. It is just a way of letting people know what is happening to the personal data that you're processing for them. So there is no agree or disagree or anything like that. It's a notice. This is what's happening. It's a bit like a sign that says a CCTV here. It doesn't really matter if you agree or disagree. You don't agree or disagree with it. It's a notice. It's telling you what's happening. So I wouldn't treat it in that sense. You might want to get, I just want to throw in, you might, if you really want to, there are, maybe you get employees to confirm that they've read and understood it. But again, do you need to do that? Is that an extra burden on employees? That's something to consider. Fundamentally, we're talking about passing employee data onto a different platform, a new platform, something additional, a new third-party service. It depends on what your privacy notice says. You can, in your privacy notice, list out the systems and the third parties by name. So you could call them out. You could say Google, Amazon, etc., etc. However, the option is available you to categorize them into things like employee HR systems, financial systems. Try and be as specific as possible is a recommendation, but you can categorize. If you're categorizing, there's no need for you to constantly update it and change it unless you are using a new category. If you're using a new category, you update your privacy notice, or if you are using the system by system approach, you add a new system and you update your privacy notice, and all you have to do is let people know that you've updated your privacy notice. Good practice is to tell them what you've updated and get people to reread it. But again, you're not really asking people to, there's no obligation to ask people to agree or sign or anything like that. So really it's just an information piece that you're letting people know. But recommendation, as I said, if you categorize well, then you won't have to do that every time. If you are able to turn the clock back and de-anonymize, it doesn't actually count as anonymous data under the GDPR. It only counts as something called pseudonymous data. So if, for example, I were to get a spreadsheet of 50 people's names and I were to replace those names with numbers, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, up to 50, pass that data on to you. You don't know you don't know those names. All you have is numbers. And so for your kind of day-to-day impression is for you that is anonymized, right? But the fact is I still hold the key. I can unlock that because I know that number 1 is John and number 2 is Sarah and number 3 is Emily, etc., etc. It doesn't actually count as anonymized. So be very careful in calling things anonymized, because I think that it's one of those unfortunate things where the day-to-day perception of anonymization is one thing, but the GDPR definition is a lot stricter than that. Also, just be mindful about how easy it is to work out who someone is. There will be times when you can genuinely anonymize things, where you aggregate stuff together and there's no way to get it back and everything, and you've just got a pile of data. So you've got an example, 50 people's data, it's all jumbled up, no one knows who anyone is, it's categorized in a way that doesn't make it obvious who the people are, you can't identify anyone out from it, then it's that's the safest way to go. And just be mindful of that though. If you say someone thought that they were filing something anonymous about someone, but they mentioned that this person had 1 leg. Well, of course, we all knew who the person was that had only 1 leg, and also you could identify from CCTV and stuff like that. So it wasn't actually anonymous. So just be careful if you're saying, someone within the age range of 30 to 35 who's a woman who is this seniority in the company. It doesn't take very much for me to look on LinkedIn and find out who that is. Just have a think, could I work this person out? Apply a common sense approach to it. They forget about the GDPR. They forget that it applies to employees. That's the biggest mistake. You can get very, I find an experience that people are always concerned about customer data and customer this and customer that, and they forget about their employees. We do lots of audits, we do lots of sessions with people. It's something that you know, Mitch. The biggest mistake that HR people teams make is they forget that their people are subject to the GDPR as well. They forget that their staff are there, are subject to it as well. So don't forget the question about privacy notices. Do we need to give staff privacy notice? They are a data subject in exactly the same way as a customer. They have the same rights as a customer. And it also means that you have the same obligations towards them as you do your customers. So you have to keep their data secure. You have to be transparent about it. You have to have purpose limitation. All the stuff that the GDPR talks about applies to your staff as well. And finally, I would say from a data subject rights perspective, obviously employees will have certain rights under the GDPR in the same way as customers. So they've got the right of access, they've got the right of rectification, all of those rights that we know about, they still apply. Staff are always going to be your trickiest ones. When you get rid of someone, you fire someone, you make someone redundant, they could put the subject access request. They are just as entitled to it as anyone else. So just be mindful of that. So top tip on there, and this comes to everything with subject access requests: write facts down. Don't write opinions. Don't write opinions about people, particularly staff members. If you're firing someone and you say they're really horrible, they're very difficult to work with, and their wife is really annoying or something like that, and they put in a subject access request, well, they're entitled to that data. So just be aware of that. So yeah, top mistake I see HR, people teams, or startups, scale-ups, enterprise businesses, anything businesses making, is focusing on the GDPR for their customers and forgetting about their staff when it comes to GDPR as well. I think the biggest risk that employees pose towards you when it comes to their own personal data is twofold. One is what I mentioned about the subject access request. They're entitled to their data. They're entitled to the same kind of things as customers. So they can be really tricky to deal with, can be really sensitive. You especially if you fire someone, make someone redundant, it's a very sensitive, difficult situation. So there's that side of things. But also, you probably, unless you work in certain industries or certain fields, the most sensitive data that you probably hold is about your staff, because you probably hold equality and diversity information. You might hold whether they're part of a trade union or not. You might hold their medical history and their medical data. You might hold their sexuality. All of these things which count as special category data under the GDPR. So we work with so many businesses where they are, say, selling, I'm going to make one up, let's say they're selling cakes. All they have customers is name, address, where they're posting it to, and payment details. And then their staff, they've got name, address, bank details, what nationality they are, what gender identity they have, what sexuality they are, what ethnicity they are, whether they're part of a trade union or not, their health records, their health data, their history, their maternity leave, their paternity leave, all of this sensitive information about them. And some of your most sensitive information is going to be on your staff. You have the same obligations to protect that as you do with everyone else. And when it comes to special category data under the GDPR, you have additional obligations to make sure it's protected. There will be additional things that apply to it, such as needing an additional legal basis in order to process that data. There's so much more to think about. And it comes back to what I said, Mitch, about businesses forget about their staff, and they come to this a bit late. But actually, that is where, for so many businesses today, their most sensitive data actually sits. So yeah, don't forget about it. When you then look at jurisdictions outside, I mean, there's two things to consider. One, if you are a business that falls under the UK or the EU GDPR, the likelihood is that you're going to have to treat your staff data according to those laws. You are still subject to them. You're still part of that, part of the jurisdiction of those laws. You're still, if say you're a UK business and you hire someone in Kenya, for example, you're still subject to UK law. You can't say, oh, well, we just do everything by Kenyan law because we want to. You're still subject most of the time to the GDPR, and you'll find that in most cases those requirements are more stringent than other jurisdictions. But if you are in other jurisdictions, it is worth looking at: are there any differences? Are there any things that apply? A big one that comes up all the time because people know about it is the California Consumer Protection Act, CCPA. And everyone thinks about that, and what if we're subject to that and that kind of thing. Well, the chances are you're probably not subject to the CCPA, because actually the threshold for that to apply is quite high, and there is a threshold beyond which it applies and below which it doesn't. Unlike the GDPR, which is just personal data, in California there's a criteria upon which it applies. So it's not always as clear cut. But the thing is, one thing I would say is anyone who works in people, HR, or anything along those lines will know you have to pay attention to international laws as well. You know, the laws in other countries will be different. So it's a tricky one. It's something to pay attention to. Likelihood is, as I said, if you are part of the UK GDPR regime anyway, or part of the EU regime, you're going to have to treat those people in the same way. And that is likely to be more stringent than anywhere else. But don't think just because you're complying with the GDPR means that everything stays the same, because like I said, some things like retention periods or the data that you can, you know, in the UK, you can use a special condition under the UK Data Protection Act of 2018 to process equality and diversity information. That's something that's in UK law. That's not in the GDPR necessarily. That is derogated to national law. Whether that's the same in Estonia, I'm not sure. So yeah, just pay attention to national legislation. There's no, unfortunately, no quick win to this. Like I say, if the GDPR applied, you're probably in the strictest regime in the world anyway.